It's Nolan. Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show. I need my credit when I'm popping shit. Shift the game like I'm driving stick. Money piling my wallet. Thick numbers looking like scholarships. I'm out there bit. Hurricane season. Send me overseas. Get a bag and I'm leaving. I'm back with the reason. I'm a rapper supreme. Like burritos on a rap for the vegans. Back to attack, make achievements. Nigga fuck a flag for religious. I put on a mask and I'm thieving. All black with a skull cap and Adidas. Insufficient funds. Fit that 150. Nigga get it done. Feeling big as pun. Industry critics don't like me. What you gonna do? Should night me? Swimming upstream so Pisces. Got a Gucci on me so icy. All the floozies. When it comes stand by me, 7-Eleven is getting too dicey. I be killing y'all nigga with the flow. Notorious big, I be kicking in doors. Leviticus niggas get spiritual, call me the bishop. I'm watching y'all decompose. I don't really need no ops, I don't need no props. I'ma sink my shot like swish. I'm a Gambino, looking for a free code, pink flamingo box. Everybody wanna know the recipe. I got my flow on the Chesapeake. I'm a SOB from the A, but my style on Texas Pete. Yes indeed. What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well out there this Friday. Now, it was brought to my attention recently that somehow I have kind of made my way into the Like That Docket. Okay, now if you're not familiar with the Like That Docket, there's two of them actually, right? So, and we're talking about Like That from Future and Metro Boomin featuring Kendrick Lamar, right? There's two lawsuits out there surrounding this particular song. The first lawsuit came in October of last year from the Barry White estate, who decided to sue Rodney O and Joe Cooley for their song Everlasting Bass. Everlasting Bass is a hit record from the 80s, very big record out on the West Coast especially, but also in all of the hip hop hemisphere, to be honest, because just like Africa Bambaataa brought that, that style, and we don't rock with him. On the West Coast, Rodney O and Joe Cooley, Everlasting Bass, kind of brought a similar vibe to the game for, having less than other things to say. You know what I mean? For lack of better terms. So, with that being stated, within the last month or so, the second lawsuit came to be from Rodney O deciding to sue the Barry White estate, but also suing Kendrick Lamar, Future, and Metro and their respective record labels for basically withholding their payment and, in their estimation, colluding with the Barry White estate to punish them for putting out Everlasting Bass, which has a similar composition to Barry White's I'm Gonna Love You Just a Bit More Baby or something. Pardon me for misquoting the direct name of the song. And that's kind of what's going on. Now, when you look further into it's a lot of moving parts with this thing. When you look further into the song, you would say, because the Barry White estate wants to own Rodney O and Joe Cooley's song, right? They want to outright own it. And the problem with that is their song didn't even sample the Barry White. At most, if they can prove it in court, it would be an interpolation, right? An interpolation is when you take inspiration from a song that you've heard, you can incorporate it into your own song in a number of ways, right? You could pull from the lyrics and remix the lyrics. That's an interpolation. You can also pull from melodies, instrumentation, and arrangements in that song and say, okay, instead of sampling it, which is taking the audio and manipulating it into mine, I can just replay it, right, in my own way, and it'll sound similar, but it's not taking the actual audio from that song. Really quickly, just giving y'all an overview of how we got to this shitstorm, right? So based on that, there's no way that the Barry White estate can own Everlasting Bass based off of alleged interpolation. You can't take ownership of somebody's song, but what you can do is say you owe me money for it. right? So when the Barry White estate sued Joe Cooley and Rodney O, they completely bypassed all the contributors on like that. They didn't target Future. They didn't target Metro, who actually sampled Everlasting Bass for the Like That beat. They didn't go after Kendrick Lamar. They say, hey, y'all are good. We going after them, right? And they've kind of been all in tandem going after Rodney O and Joe Cooley. Just giving y'all a quick overview. If you want more information, I have a very long video and an interview with Miss Nicole Key, who represents Rodney O as his rights manager, and she's also, kind of helping him in this pro se situation, being that he's got to represent himself, because based on the way that they wanted to approach this, their legal representation would not agree. Okay, so their legal representation left. Just trying to be succinct as possible, give y'all the information and keep going. All right. So a few weeks ago, we get Nicole Key on the channel. She wants to plead her case. You know what I'm saying? After the social media storm, after TMZ and everybody picked up on the fact that Rodney O sued Metro, Future, and Kendrick and all of them, along with Sony, along with Epic, along with UMG, if I'm not mistaken. All of them, Republic. So all of this is coming out, and I'm like, well, I see Nicole's name in this. I know Nicole. She hits me and was like, yo, what's up? She's trying to tell me I got it all wrong with some of the things. She comes on a channel. She does an interview. She tries to clarify her stance, try to clarify Rodney's stance as to why this is so important. Again, if you want to see that interview, it's on the channel. But now it seems that the interview that I did with Miss Nicole is now being cited in the docket in the original lawsuit, okay, from Barry White estate versus Rodney and Joe. And the context in which my interview has been brought up is because Rodney O does not believe that there should be a protective order placed on this case, okay? Because the Barry White estate wants them to not be able to speak out, right? And they cite emails, they cite social media, all of this different stuff as to why this thing should be a little bit more protected, a little bit more private, right? Rodney O, on the other hand, is like, nah, this is actually, we need to get this information out there so y'all can't silence us from telling our side of the story. Now, I'm going to work my way up to the part where this interview that I conducted gets brought up, because I just want everybody to be as familiar with what's going on as possible. I know it's confusing. This is copyright, IP law. This is not stuff everybody deals with on a daily basis when we're talking about samples, interpolations, who owns what. Yeah, we have general conversations about this, but this is a very, very, very deep situation. And there's a lot of moving parts, a lot of people involved. And it seems like a lot of people neglected their duties in order to get here. So what I'm going to do is go ahead and share my screen. I'm going to pull up the original complaint from the Barry White family estate. It's only 9 pages. It's not one of these long-ass lawsuits, thank God. This was submitted to the courts on October 3rd of 2024, just to give you an overview of what their actual grievances are. Okay, so we're going back to October here. United States District Court, Southern District of New York, Barry White Family Trust versus Joe Cooley, Rodney Oliver, and Rodney's Publishing Company. The Barry White Family Trust, UAD, December 19, 1980, Barry White Trust, by and through its co-trustees, collectively plaintiffs, allege as follows. The Barry White Trust is a trust duly created and existing under the laws of the state of California by its duly empowered trustees, Glodine B. White and Jack W. Perry, and is the successor in interest to all of the rights held by the late Barry White. Upon information and belief, we don't need to have their personal information out there. I'm Gonna Love You Just a Little More, Babe was written and produced by Barry White in 1972 and released in 1973. The copyrighted work, a copy of which can be accessed through the link attached. The copyrighted work was copyrighted on January 8th, 1973 and received an original registration for Words and Music, registration number Blase, which was renewed on January 5th, 2001. If you actually watched my interview with Nicole, she made reference to this, but she said that the renewal of the copyright actually went to Warner, not the Barry White Trust, so they can't really come out on behalf of them unless Warner is included, which she claims they're not. Okay? Like that, the infringing work copies substantial elements of I'm Gonna Love You Just a Little Bit More, Babe, based on license from defendants for use of their song Everlasting Bass, which infringes the Barry White copyright, including but not limited to the iconic, immediately recognizable bass line from the copyrighted work. Okay, we don't need to know about the jurisdiction and venue. That's not important to us, but it will be in New York because they filed this federally, if I'm not mistaken. Okay, preliminary statement. Plaintiff's commitment to preserving Barry White's musical and artistic legacy. During his lifetime, Barry White established himself as a legend in the entertainment business. Barry White's popularity has only grown since his untimely death on July 4th, 2003 at age 58. Since his death, his estate and subsequently his trustees had judiciously guarded the manner in which Barry White's name, image, likeness, trademarks, copyrights, and music have been licensed. Barry White was a legendary two-time Grammy Award winner. His music transcended a generation of fans and has endured for almost half a century. For some, Mr. White was the man of soul on the smash hit television series Ally McBeal. For others, Mr. White was the grandfather of love for his sultry renditions of classics such as I'm Gonna Love You Just a Little More, Babe, from White's 1973 album I Got So Much to Give, which was certified as a gold record. Mr. White achieved 106 gold albums worldwide, god damn, including Stone Gun, okay, Just Another Way to Say I Love You, Barry White Sings for Someone You Love, The Man, and Can't Get Enough. Barry White had 20 gold and 10 platinum singles with worldwide record sales in excess of 100 million records and is one of the best-selling music artists of all time. Put some motherfucking respect on that. In addition to his distinctive voice, the maestro was also known for recording and performing with his 40-piece orchestral group. Mr. White's iconic signature sound and performance style was a combination of an instantly recognizable bass baritone voice backed up by his lavish production and copyrighted orchestrations with a full symphony orchestra comprised of accomplished musicians. Mr. White's enduring achievements, including his multiple gold and platinum albums, is testimony to both his ability as an incredible writer and unparalleled performer. So they building up how iconic he was in the industry. All great. Now, getting to the background. Mr. White was a gifted musician, songwriter, record producer, and composer. He wrote iconic masterpieces, Can't Get Enough of Your Love, Babe, Love's Theme, Never Gonna Give You Up, and You're the First, the Last, My Everything. Plaintiffs are the successor in interest to the copyrights for Barry White's music. Plaintiffs hold a registered copyright. Now they get to Like That. Like That is a song by American rapper Future and American record producer Metro Boomin with fellow American rapper Kendrick Lamar. It was sent to U.S. Rhythmic Radio through free bands under the business name Wilburn Holding Co., Boominati Worldwide, Epic Records, and Republic as the third and final single from Future and Metro's collaborative studio album We Don't Trust You on March 26, 2024. Rodney O and Joe Cooley are also credited as songwriters, as the bass line in the song contains samples of their 1986 song Everlasting Bass. Like That debuted at number 1 on the Billboard US Hot 100 for the chart issued dated April 6, 2024 with 59.6 million streams, 9,000 digital downloads sold, and an airplay audience of 5.6 million. Now they get to Everlasting Bass itself. They say this song never charted when it was released. Why y'all gotta throw shade like that, man? This song never charted when it was released in 1986. A copy of Everlasting Bass can be accessed through the link. Plaintiffs seek damages for all reproductions and samples of Everlasting Bass within the statute of limitations. Okay? So they want Rodney O and Joe Cooley to pay up, right? They want damages for all reproductions and samples of the song because they believe that the song samples from Barry White. Although it does not sample from Barry White, at most they would have to prove interpolation. Okay? Which I say that for a reason, because you can't just say it. You got to prove it in court first. First claim for relief. They want copyright infringement. Plaintiffs repeat and reallege all prior allegations of this complaint. At all relevant times, plaintiffs are and have been the rightful owners of the Barry White copyright. As such, the plaintiffs have the exclusive rights to reproduce the Barry White copyright or prepare derivative works and public displays. The defendants have no license or any other form of permission to copy, duplicate, synchronize, sell, perform, or distribute any portion of the Barry White copyright. The conduct of the defendants is knowing and willful, since the internet is replete with websites which recognize that the Everlasting Bass song interpolates the hook or riff off of Barry White's copyrighted work. That's very true. That's what I said in my initial video before I spoke to Nicole. We also spoke about that in our interview, and she says that it is actually a very common riff that predates Barry White's song. So who is the originator of that selection? One or more of the defendants infringed on plaintiff's exclusive copyright in I'm Gonna Love You Just a Little More, Babe, when it distributed and sold sound recordings, including compact discs, phono records, digital downloads, licenses, streaming, ringtones, ringbacks, all other economic exploitation, and video recordings embodying like that. Such reproduction and release were wholly unauthorized, as it was without any license or consent, of authority from the plaintiffs. They say y'all didn't come to us for nothing. By virtue of this unauthorized commercial exploitation, defendants have realized illegal revenues. So from the Barry White estate's perspective, they say since 1986, y'all have been making money off of this song, which allegedly incorporates parts of Barry White's song for nearly 40 years. And we want to be compensated for that. The defendants infringed plaintiff exclusive copyright and I'm Gonna Love You Just a Little More, Babe, when they issued and or authorized others to issue licenses to third parties for the use, publication, exploitation of like that. Said licenses were issued without any consent or authority from the plaintiffs. By virtue of this unauthorized commercial exploitation, defendants have realized illegal revenues. Now, what I find interesting is they don't want no money off of like that. They want the money from Everlasting Bass, which I find strange. Gotta be honest. As a direct and or approximate result of the defendant's infringement on plaintiff's exclusive copyright and I'm Gonna Love You Just a Little More, Babe, plaintiffs have suffered damages. Said injuries are continuing and will not abate in the future. By their actions stated in detail above, included but not limited to copying all or substantially all of the musical compositions, incorporating such composition into the infringing work, creating derivatives, and by the exploitation, publishing, performing, and distribution of the copies and the unauthorized derivative versions, the defendants have infringed and will continue to infringe plaintiff rights in the Barry White copyright in violation of the Copyright Acts 17 U.S.C. 501 and 106. Okay? We don't got to go too much further. They want some motherfucking money, all right? And the damages, they say, exceed $150,000. Okay? Prayer for relief. They want for judgment, the defendants have violated the Copyright Act. For judgment, assessing defendants for the damages in excess of $1 million. Suffered by plaintiffs, including an award of actual damages and defendants' profits attributable to the infringement or statutory damages under the Copyright Act, as well as costs and attorney's fees to the full extent provided for by sections 501, 504, and 505 of the Copyright Act. So they want over $1 million. Okay. And they want all of these different forms of repayment. They want money off record sales, downloads, ringtones, ringback, public performance revenues, digital revenues, streaming revenues, sync licensing revenue, which is when your song is played in TV, film, or other productions that feature music, merchandising, public appearances. If they played your song before you came out at the club, we need to know what the fuck going on. Endorsements, sponsorships, spokesperson work. God damn, spokesperson work. So if I got booked to go be an inspiration to kids, you want me to goddamn break y'all from that too? Touring revenue, advertising revenue, appearance fees, increased value of defendants publishing and or record company and or companies, increased value of music publishing and or record royalties and rights. A lot of this, I ain't gonna lie, this shit is I'm getting tongue tied just thinking about it. This shit is excessive as the fuck. Increased value of social media rights accounts and value, any and all music publisher income. Basically they saying, and to be somewhat fair, they trying to say you wouldn't have no career without this song that pulled something from our song. Right? We ain't got to keep going through all this shit. They want any and all. Any and all? What you mean all? Music publisher income, any and all record master income, any and all record income. They want all the sound exchange, BMI, ASCAP, PRS. These are, once you get past BMI, ASCAP, PRS, that's international revenues. CSAC also. PPL, that's out there in the UK. SOCAN, that's Canada. MCPS, Harry Fox. They say we want all the everything. They ain't no fucking way you're going to get all the everything, especially since they didn't sample your song. They may have interpolated it, but interpolation costs way less than a sample. And you got to prove that first, all right? But this is what they want. SAG-AFTRA money. They want goddamn everything. Okay? Which I gotta be honest, that's a hell of a lot. They want your whole existence. So, and I want to go ahead and try to give y'all a little bit of context, right? If you saw my interview with Miss Nicole Key, if you see that she was frustrated, you see that she kind of took some of that frustration out in the direction of Kendrick Lamar. And I know a lot of people don't like that. I know a lot of people felt slighted about that. You got to also think, if you were in this position, right? And Kendrick definitely didn't deserve none of this. I'm gonna be honest. I stand on that. I said that to Nicole. But they're looking at Kendrick, Metro, Future, who sampled their song. And because you sampled this song, we now have this big shit storm coming from the Barry White people, and they're trying to take this man's everything, and Joe Cooley, right? So they're trying to take whatever is remaining of their 40 years of having this song out. They want it all. And if you were sitting in their position, I think you could understand the type of pressure they're feeling for something like this. Not saying that I agree with everything that they're doing. I'm just saying I can understand why a person would be frustrated and perhaps lashing out, feeling like the walls are caving in on them. Not to mention, ever since like that came out, Rodney and Joe Cooley have not been receiving royalties. There was a $40,000 payment or something like that was given at one point. But other than that, no royalties have come in their direction. However, others have been receiving their royalties from this record. The only cash flow that has stopped has been for Rodney and Joe Cooley because of this. I'm going to try to get through this as quickly and simply as possible. On May 8th, before this thing was put out, Rodney O wrote a letter to the judge asking for the Barry White Trust to show proof of their ownership of the copyright for the Barry White song. They want proof of the actual composition, right? To show the musical notes and arrangement of the sheet music that the Barry White Family Trust alleges that Rodney O and Joe sampled. It's like, hey, if you say we sampled your song, show us proof of the notes that we sampled and show us that they are identical as a sample, right? Or prove that we interpolated it, right? Which I personally believe there's an interpolation. I don't, but it's not sampled. But again, that's just my opinion. But at the same time, they've shown proof that, again, that arrangement pre-existed Barry White doing it. So who is the original owner of the arrangement, right? They also asked for the judge, hold on, y'all, to compel Sony, Epic, and Republic to clear the money that Joe Cooley and Rodney are owed for the Like That sample being used, or the Everlasting Bass sample being used in Like That. Because they like, hey, we're not eating. They sampled our shit. They getting money off of it. We not eating. We out here fucked up. And we facing legal ramifications. We can't afford to even properly defend ourselves because we're not making money off of the song, right? So on May 8th, that goes out. On May 9th, or was it May 8th? I can't remember. All of this shitstorm hit social media because they go and file their own lawsuit against Barry White, Future, Metro, Kendrick, Epic, and Republic, right? May 10th, I do the interview with Miss Nicole Key, and it comes out on YouTube. All right? Just catching y'all up on dates. On May 16th, which is what we're looking at now, the Barry White Family Trust sends documentation to the court and says that we need a protective order and confidentiality agreement placed over this case. Okay? Because Miss Nicole Key is she's already been talking about it publicly on social media. She's been posting it. But then she came and did, about an hour conversation with me talking about the situation, right? So let's get into this proposed protective order that came from the Barry White Family Trust. Okay? So this is the proposed protective order and confidentiality agreement, whereas the court, having found that good cause exists for the issuance of an appropriately tailored confidentiality order pursuant to Rule 26C of the Federal Rules of Civil Procedure, it is hereby ordered that any person subject to this order, including without limitation the parties to this action, their representatives, agents, experts, consultants, all third parties providing discovery in this action, and all other interested persons with actual or constructive notice of this order shall adhere to the following terms upon pain of contempt. Any person subject to this order who receives from any other person any discovery material, i.e., information of any kind provided in discovery in this action that is designated as confidential pursuant to the terms of this order, shall not disclose such confidential discovery material to anyone else except as expressly permitted hereunder. Publicly available documents are not confidential pursuant to this provision. All right. So they're saying whatever's out in the public is fine, but anything that is produced for discovery material or seen as confidential, if it comes out in any other area, the person who allows that to be put out shall be punished, right? Very simple. The person producing any given discovery material may designate as confidential only such portion of such material as consists of previously non-disclosed financial information, including without limitation profitability reports or estimates, percentage fees, design fees, royalty rates, minimum guaranteed payments, sales reports, and sale margins. Previously non-disclosed material relating to ownership or control of any non-public company. Previously non-disclosed business plans, product development information, or marketing plans. Any information of a personal or intimate nature regarding any individual or any other category of information herein given confidential status by the court, which I think for the most part is pertaining to Rodney and Nicole's lawsuit against Barry White and co. We're just gonna say, because in their filing they have intimate details about who was supposed to be paid what. They have email correspondence between themselves and the label. They have email correspondence between themselves and the licensing company. They have email correspondence between themselves and Miss Weber from the Barry White estate. All of these things are there. They have agreements of, what they were supposed to be paid for the licensing of Everlasting Bass to appear on like that. And these are all documents that I'm quite sure the Barry White estate would like to remain confidential, not public information, right? So they're saying, hey, we need all of this stuff to be sealed. Okay? Where was I at? With respect to the confidential portion of any discovery material other than depositions, transcripts, and exhibits, the producing person or that person's counsel may designate such portion as confidential by stamping or otherwise clearly marking as confidential the protected portion in the manner that will not interfere with legibility or audibility, and also producing for future public use another copy of said discovery material with the confidential information redacted. With respect to deposition transcripts and exhibits, a producing person or that person's counsel may indicate on the record that a question calls for confidential information, in which case the transcript of the designated testimony shall be bound in a separate volume and marked confidential information governed by protective order by the reporter. They're just going into all of the things that shall be protected as confidential, or at least what they're asking for, because it has not been signed by the judge, right? This is just what they want. This is the Barry White estate, by the way. Again, very confusing. You got to listen intently, and I got to do my best to keep reminding you who is submitting what, right? Because it's so much. Way more than I care to talk about. So boom, if at any time prior to the trial of this action, a producing person realizes that some portions of discovery material that person previously produced without limitation should be designated as confidential, he or she may also designate by so apprising all parties in writing, and such designated portion of the discovery material will thereafter be treated as confidential under the terms of this order. No person subject to this order other than the producing person shall disclose any of the discovery material designated by the producing person as confidential to any other person whomsoever, except to parties of this action, counsel retained, as to any document, its author, its addressee, and any other person indicated on the face of the document as having received a copy, any witness, any person retained by a party to serve as an expert witness or otherwise provide specialized advance to counsel in connection with this action, provided such person has first executed an NDA not to share that information as themselves, stenographers, the court and its supported personnel, all confidential discovery material filed with the court, all portions of pleadings, motions, and other papers filed with the court that disclose such confidential discovery material shall be filed under seal and kept under seal until further order of the court. All right. Y'all pretty much get what they saying here. I don't want to make this longer than it needs to be. But as of yet, this was on the 16th of the month, proposed by Barry White Trust. Also filed on the 16th is this letter to the court from the Barry White Estate Family Trust. And here they say to the judge, plaintiffs write in connection with several matters which have impeded plaintiff's ability to submit a joint confidentiality agreement by May 16, 2025, confidentiality order. Despite plaintiff's good faith efforts, we have been unable to come to any agreement with the defendants in connection with that confidentiality agreement, right? So they've been trying to figure out what was going to be deemed as confidential, and they have not been successful in coming to an amicable agreement. On April 14th, 17th, so they go back into last month, 21st, 29th, and May 6th, we sent Mr. Oliver and Mr. Cooley a draft confidentiality agreement based on a standard confidentiality stipulation used in the Southern District of New York. On Thursday, April 24th, 2025, immediately after the initial conference, we emailed both defendants requesting that we have a call on Monday to discuss some of the outstanding issues, including a potential settlement discussion. Okay, now be clear, the potential settlement discussion was not about any money. They were actually going to offer, they did offer Joe Cooley an opportunity to be removed from the lawsuit from the Barry White estate, which he declined. Okay. When we sent defendants a courtesy copy of the scheduling order, I again asked about the call on Monday, saying I really do think we could make progress on a call. For whatever reason, that call seems to have never happened. On May 6th, 7th, and 12th, and 14th, we wrote to defendants and attempted to work with defendants to come up with acceptable language for the confidentiality agreement. On May 7th, Mr. Oliver, that's Rodney, aka Rodney O, he wrote to us rejecting our drafts. On May 8th, Mr. Oliver also notified the court that he had rejected the draft confidentiality agreement. Okay? The confidentiality agreement is also guided by the conduct of Mr. Oliver and Ms. Nicole Key, now a party in the second action as defined here and below, because they have embarked on a media campaign which goes well beyond discussing pending litigations. Mr. Oliver, in a recent TMZ interview, had a headline stating, "And Barry White estate is lying." That's what he said to TMZ. See the TMZ interview clip and other social media attached here too as Exhibit 3 in view of defendants' conduct. It is particularly important that the plaintiff's documents be protected from what appears to be a media campaign designed to avoid the merits of the litigation and is instead focused on unfounded, increasingly aggressive vitriolic attacks in connection with the Barry White Trust copyright infringement action. Plaintiffs have a reasonable apprehension that documents other than publicly filed documents will be improperly used. Plaintiffs respectfully request that the court approve the proposed confidentiality agreement filed on May 16th. Okay, second action. After the conference with the court on April 24th, 2025, Mr. Oliver and Ms. Key filed a second action, Oliver et al. Versus Barry White Family Trust, which is currently pending before Chief Judge Swain and Judge Swain, and which has not been served. The second action names Futures attorney Robert Finan, Esquire of Greenberg Traurig LLP, and myself as defendants. After filing the second action, Ms. Key solicited me to drop the Barry White Family Trust case. This was clearly an improper quid pro quo attempt to pressure me to compromise my client's interests. Okay. Defendant's motions. In connecting with the second action, Mr. Oliver initially agreed that it should be consolidated with this action. Mr. Oliver now opposes his own prior motion to consolidate. In an email dated May 9th, Mr. Oliver said he had a lawyer. We asked him to confirm, but have not yet received a response. Emails dated May 9th, 12th, and May 14th. We respectfully ask the court to set a scheduling order in connection with the communications that Mr. Oliver has filed with the court, some of which appear to be styled as motions. In furtherance of our letter dated May 6th, and as set forth herein, we also respectfully ask the court to schedule a conference. So now they're trying to get a conference where they can talk some things out and to also figure out what should be held as confidential and what not. So then they get into emails. Okay. And again, I don't want to get into the weeds of all this because I don't think y'all really care. Okay. But this is just email correspondence between all of them to try to come to some sort of amicable agreement of when to have the conversation about confidentiality, right? This is all of the attempts from the parties. Okay. And the resistance from Joe Cooley, Rodney O, etc. Okay, we'll continue. So here on May 20th, we get an order from the judge, from Denise Cody, district judge. Okay, she states, an order of April 25th, 2025 set a schedule for this action. This order addresses correspondence from the parties that has been filed since May 1st. It is hereby ordered that the plaintiff's counsel, having filed a proposed protective order and confidentiality agreement on Friday, May 16th, the defendant shall file any request for amendments by today. So Rodney O and Joe Cooley have till the end of the day today to request any amendments that they feel are necessary in the proposed protective order and confidentiality agreement. Okay, we'll see how that goes. It is further ordered that requests to consolidate this action with other actions which have been or will be filed in this district, including the requests made on May 1st, are denied as premature. Should a party file another action by paying the required filing fee or by obtaining approval to proceed in forma pauperis, the newly filed action must be served on the defendants. Should a party request consolidation at that time, all parties to the newly filed action and this action will be given an opportunity to be heard on the issue of consolidation. It is further ordered that defendant Oliver is Rodney O, by the way, once again, May 8th motion to compel is denied. So when he asked for them to provide their proof of copyright and sheet music and have the labels and everybody clear the money for him and his partner, the judge says no. The parties were required to serve their document requests on other parties by May 16th. So for whatever reason, Rodney failed to serve documents. Okay, a motion to compel may only be filed if a party fails to produce the requested material within the time permitted by the federal rules of civil procedure, this court's orders, or the parties' agreement. The parties are reminded not to file their discovery request or response with the court. The materials are to be exchanged among the parties only. Moreover, materials in civil litigation are generally exchanged after the parties have negotiated and executed a protective order, which is then submitted to the court. Okay, so everybody's kind of moving a little wonky here, according to the judge. It is further ordered that defendant Oliver's May 8th request to compel Sony Music or Epic Records to release funds to him is denied. Neither organization is a party to this litigation, so we can't make them send you no money. They're not even involved in this particular case. I can't tell them to just pay you. That's what the judge said. Neither organization is a party to this litigation. The federal rules of civil procedure govern the conditions for taking discovery of non-parties. The request to compel production of documents by either Sony Music or Epic Records is also denied. It is further ordered that by Friday, May 23rd, any party must advise the court if it requests a jury trial. So they also have to let the courts know today if they want this case to be seen before a jury. Ms. Cody says, it is appearing as of now that no party requests a jury trial. If no request for a jury trial is made by May 23rd, an order shall issue, setting out a schedule for the filing of materials in October 2025 related to a non-jury trial to be held in November. So this thing is going to continue, all right? They'll get the schedule outlined for October to start a trial in November to be held before the judge, no jury. It is further ordered that the plaintiff's May 6th request for a conference is denied without prejudice to renewal. Okay? So it seems everybody involved, from the Barry White estate even down to Rodney and Joe Cooley, are kind of moving out of their own jurisdiction. They're trying to overstep the boundaries of the court. And the judge is saying no. So here we have paperwork filed from Joe Cooley, who is a co-defendant with Rodney. And they are also, of course, music partners, or at least they used to be. Where he speaks to statement on withdrawal and request for equal consideration. Remember, it's been said that the Barry White estate offered Joe Cooley an opportunity to be dropped from this lawsuit. He says no. Here's his reasoning. Dear Judge Cody, I'd like to address the plaintiff's recent decision to withdraw its claim against me and explain why I believe this raises larger questions about the case overall. Plaintiff's counsel stated, the public records show your writing interests. Based on your representations, we are withdrawing the claim against you. Nothing was done maliciously or in bad faith. Right? So the Barry White estate is like, hey, Joe, we really just want to take down Rodney. Okay? We don't want to take you down with him. If you're willing to walk away from this, we see that you got some interest in writing on this record. We really ain't got no problem with you. Joe says, well, if you ain't got no problem with me, then why is this lawsuit still active? Right? So he says, respectfully, this statement is both legally and logically inconsistent with the claim of copyright infringement at the heart of this lawsuit. If the plaintiff believes that Everlasting Bass infringes a Barry White composition and then acknowledges that public records show I have writing interest in Everlasting Bass, they are effectively saying we're dropping the case against someone who helped create the allegedly infringing work. That doesn't make legal sense unless the case itself was weak to begin with. In fact, if the plaintiff truly believed that I had a writing interest, I would expect them to continue with discovery to disprove that interest. Instead, they are withdrawing their claims solely based on my statements, not evidence. If my own statements alone are sufficient to dismiss me, despite the plaintiff's admission that I may have co-authored the alleged infringing work, then it follows that either Mr. Rodney Oliver shares the same defense or that the entire foundation of the plaintiff's claim deserves reevaluation. And I don't disagree with Joe. If you're willing to excuse me as somebody who co-created this, but y'all are claiming that y'all want all of the earnings ever made from this song, how y'all supposed to let me free and then bring the hammer down on this nigga? How you gonna separate us when we're both co-defendants? Unless y'all are trying to get him to flip on his own homie. But I can't say that. That was just a thought. I don't know what they doing. He says, what I've been asking for and still haven't received is basic documentation showing that the Barry White Family Trust owns the work and that their attorney had the legal authority to bring this lawsuit. That hasn't been provided. I believe the real reason the plaintiff is letting me go is because I've been pressing for answers. Dropping me now feels more like a way to avoid those questions than an acknowledgement that I never should have been named. This lawsuit put me under real pressure. I didn't write or produce Everlasting Bass, but being threatened with $1 million claim pushed me to defend myself in ways I now regret. I spoke out publicly under stress and wrongfully placed blame on Rodney. So all that talk about him like not fucking with Rodney, you brought me nothing but stress in the time that we've been together in this industry. Remember, we talked about that. Like, damn, your own partner said fuck you. He says, I regret saying that. I was publicly under stress and I threw him under the bus wrongfully. He says, I didn't understand the full situation at the time. Rodney has supported me despite how I acted, and I appreciate that. The lawsuit hasn't just hurt me, it's hurt both of us and the legacy we share as pioneers in West Coast hip-hop. Everlasting Bass is part of that legacy. I respectfully ask that my participation in this case not go without purpose. I asked the court to require the plaintiff to provide the documentation I've been requesting, not to justify my dismissal, but to ensure that Rodney is also cleared from this case. If I'm being released based on facts the plaintiff refuses to make public, then Rodney deserves that same consideration. Hey, I ain't mad at that. Now, I don't know if this letter is going to hold any weight to the judge. I don't even know if this letter is, submitted properly. But so Joe Cooley is representing himself also as pro se. So what is this? This is April 25th, an email from Miss Dorothy Weber, who is representing the Barry White estate. She says, "Hi, here is a courtesy copy of the order filed on ECF today. Please let me know about Monday. I really do think we can make progress on a call." Ricardo Rosado comes back, says, "See attached, sincerely." I don't see an order to have a call. Okay, so Joe responds. He says, "I don't see any order." No, this is old. So this is strange. So this is from April. This is the 19th, okay, of this month. Joe says, "I don't see any order to have a call. The judge suggests we pick up the phone, but it is not required. I feel more comfortable if what we say is documented." Okay, so he doesn't want to speak on the phone off the record. He wants all communication to be documented. "We are communicating just fine. I am not refusing to provide you anything or not communicate, although you lied to the court and said different. Can I record the call?" Okay, he says, "If we get on the phone, do I have permission to record?" Joe sends an email to Miss Weber, says, "I will sign if you edit the settlement to state the following." Okay, so he says, because Miss Weber offered him an out, and he said, "I'll sign it if you do XYZ. So XYZ consists of a statement. He wants her to state, "I am willing to sign a mutual dismissal agreement if the plaintiff acknowledges in writing that I was not a proper party to this lawsuit and that my inclusion caused reputational and professional harm. If it is later shown that the claim against me was brought maliciously or in bad faith, I reserve the right to seek further relief, including a public apology and appropriate remedy." So he says, if you put this verbiage in the settlement, which completely absolves me, lets it be known that you caused reputational and professional harm to me, and let the people know that this was potentially brought against me maliciously or in bad faith, then y'all gonna pay me out and give me a public apology. I'm quite sure Miss Weber said hell no. Matter of fact, here's the follow-up. She says, "Sorry, Mr. Cooley. Those statements are not correct, so they cannot be added. The public records show your writing interest. Based on your representations, we are withdrawing the claim against you. Nothing was done maliciously or in bad faith." So this is what Joe is referencing in his letter to the judge. He's saying she's trying to remove me from the lawsuit, but I don't understand why she's removing me if they're acknowledging that I have writing interest in a so-called copyright infringement case. Why would y'all let me go for copyright infringement without dropping the case altogether? Y'all just want me to leave, stop asking questions, so that y'all could pounce on Rodney. Y'all do with this information what y'all will, man. I'm just trying. Hey, I stopped even talking about this shit, man. So he's submitting these emails to the judge to let it be known this is what they offered me. I don't want this shit. Very same day, Rodney writes to the court. Okay. He says he submits a letter. Defendant Rodney Oliver's motion to address pattern of gamesmanship and abuse of process. Okay. So he wants the judge to look into the Barry White estate for abusing due process. Okay. So he says this motion seeks narrowly tailored relief following plaintiff's continued refusal to produce foundational documentation necessary to maintain a copyright claim under federal law. This is a copyright case after all, but I think they're trying to skip the discovery process, which the judge said you can't. I mean, y'all can produce this stuff, but it can't be submitted to the courts as of yet. The record reflects procedural misdirection by plaintiff's counsel that undermines judicial efficiency and prejudices defendant's ability to prepare a defense. Legal framework. A copyright registration is a statutory prerequisite to suit. The alleged infringement must be based on the deposit copy filed with the U.S. Copyright Office. Procedural tactics that avoid resolution of such statutory elements may warrant sanctions. Procedural history. Plaintiff has failed to produce the sheet music deposited at the time of copyright registration for compositions registered prior to January 1st, 1978, Courts must compare the alleged infringing work to the deposit copy on file with the U.S. Copyright Office, not to a sound recording, okay? So for whatever reason, I don't understand the law of compositions prior to 1978, but they're saying that back then, for things that were submitted via copyright, you can't just listen to the song. You have to pull up the sheet music, probably because there were so many common grooves that these groups used to use amongst each other, that if you simply listen to a song, you'd be like, oh, I hear that, I hear that, I hear that, I hear that. But if it's not in the sheet music, then it's not copyrighted. That's what they're trying to say, right? And then they cite Three Boys Music Corporation versus Bolton, Skidmore versus Led Zeppelin. By producing only audio, plaintiff not only impairs defendant's ability to prepare, and A, I don't even know where that looks like an incomplete sentence there. Plaintiff has not produced a valid registration naming the Barry White Family Trust, a copy of the deposit material, trustee authorization to file this action. Counsel instead responded with allegations against defendant and his rights manager, Nicole Key, whose May 5th request for such documents was rebuffed without substantive reply. This pattern mirrors litigation strategies used by plaintiff's counsel in prior actions, including Stroud versus Castle Rock Entertainment and Methevin and Associates versus Parody Stroud, where courts were required to intervene due to misuse of process. So they're saying that, this Miss Weber has been pulling this type of stuff repeatedly, and the courts have intervened in the past based on the same precedent. Okay, that's Rodney's perspective. So what he wants is a request for relief. Defendant respectfully requests that the court compel immediate production of the required documents, the copyright sheets, dismiss and the sheet music, dismiss the action or impose sanctions for gamesmanship. All right, so he's still saying this needs to be dismissed, or you need to impose sanctions for gamesmanship because they playing. We also have, that's the certificate of service. Y'all don't need that part. And we have an affidavit from Miss Nicole Key, who spoke to us on this channel. And this is basically like a declaration to the court, basically. Miss Weber has repeatedly made representations that are either unsupported or contradicted by the record. Her characterization of my communications as solicitations lacks any evidentiary support, and yet she appears to expect the court to credit these assertions without scrutiny based on her own conduct throughout this litigation. There is no basis for the court to rely solely on her word. She says, I am a co-owner of the sound recording at issue as rights manager and co-plaintiff in a related copyright case. I also advise defendant Rodney David Oliver. On May 5th, I submitted a written request to plaintiff's counsel, Dorothy Weber, for the copyright registration, naming the Barry White Family Trust, the deposit copy of the alleged work, documentation of trustee authority under 17 U.S. Code 501B. She says, I made this request professionally and in good faith as part of my role in helping clarify ownership rights and protect all rightful stakeholders. So she's trying to say, hey, we're trying to do this the right way, but nobody has demanded that the Barry White estate actually show their copyrights. They say they've copyrighted it, but nobody has asked them to produce the copyrights and the sheet music, which would basically show whether or not it was actually included. And if it indeed was included, then they would be within their rights for interpolation claims, right? Very same day, Rodney submits his objection to the proposed protective order that the Barry White Family Trust issued to the courts. So he's saying we because they had to submit they were supposed to submit any amendments that need to be made. He outright comes and objects. I don't know how the judge is going to react to this, because I don't think this is what they asked for. But this is an objection to the proposed protective order, okay? I don't want to read through this because we know what the grounds are for Rodney and Joe. They say, please just show us the copyright. Y'all are doing all of this extra stuff. Y'all are going around the world. The easiest thing to do is show us the copyright, Show us the sheet music that you claim we infringed on, and we can decide whether this needs to go forth or not, right? From a simpleton perspective, that makes sense, but I don't know how that applies legally, right? I'm always transparent about that. Now, I'm sure y'all been sitting here for an hour like, God damn, J Nolan, you're telling us all this shit. You say you're a part of the docket. Where you at? This is where I'm at, all right? This was filed on the 21st, 2 days ago, on Wednesday. I was not made aware of this till yesterday, okay? So shout out to ABSA, because I believe she's the one that actually went through the documents and put this out there. People that saw her video came and let me know what the hell going on, all right? So now we have a declaration from Miss Dorothy Weber, which is the lawyer representing the Barry White Family Trust, and she is saying, hey, I ain't fucking with that opposition or that objection for the protective order. So here's my opposition to that. Here's why the protective order should continue. Okay? So she says, I, Dorothy M. Weber, hereby declare I am a member of the firm Herbsman Hafer Weber, and Frisch LLP, and I am admitted to appear before this court. I am submitting this declaration in opposition to Defendant Oliver's objection to proposed protective order. Attached as Exhibit A is a recent interview regarding this case and counsel, spearheaded by Nicole Key, who is attempting by indirection what she could not achieve directly with the court. Clearly, that interview is with me, but you'll see it in the exhibit. Okay? Ms. Key clearly needs to be a signatory to the confidentiality agreement, since she is clearly still representing Mr. Oliver in this action. Nothing herein is meant to stop the parties from discussing the case, but the defendants must ultimately be held responsible for lies they disseminate and their fabrications, such as inter alia. The Southern District of New York has sua sponte reassigned Oliver et al. Versus Barry White Family Trust to Judge Laura Taylor Swain. This rare move, initiated by the court, not by motion, signals the seriousness of the claims raised by Rodney Oliver and Nicole Key, including allegations of misconduct by the trust legal representatives. See Exhibits A and B attached here too. The plaintiffs request that the proposed confidentiality agreement be so ordered and that the defendants and Ms. Key be bound by it. So they claim, we're not trying to stop you from talking about this, but Ms. Key will also need to sign off on the confidentiality agreement to understand what and what cannot be shared. Okay? So that's Miss Dorothy Weber. And Nicole claims she feels like Miss Weber is trying to do exactly that, as in silence them from talking about it. Because nobody silenced Miss Weber and the Barry White estate from sending out information to the press, talking about it to the press in any way. They may not be doing interviews, but they're directly sending this stuff out to TMZ and all of these different platforms. So they're trying to refute what's being put out. They're doing their own, whatever they want to call it, crisis management. I don't know. So Exhibit A is Nicole Key's interview regarding lawsuit. All right. So this is a link. We're going to click on the link. I feel like it's more so, it takes us to Kendrick Lamar, Future, Metro Boomin, like that lawsuit part 2. Nicole speaks out for Rodney O. This is where it takes us. They even got they took it straight to the part that they're concerned about. Let me let this play for a second. I don't know what we were talking about here. Future and Metro, they're out.
I sent an email to all artist teams.
Right.
Heads up. Not sure if you know this is happening.
Mm-hmm.
I just want to let you know, because it's going to escalate. And it escalates and you guys don't do anything, I'm going to be complicit. And I'm going to see it as you agree with how this is.
Okay, so Miss Nicole at this point was talking about how she emailed Metro, Future, and Kendrick Lamar's teams, whoever she had access to, and let them know this is coming down the pipeline. If y'all don't do anything about it, y'all are going to be held liable, and we're going to accept this as y'all being in on it, right? So she tried to give everybody the opportunity to speak out, to try to come to some sort of agreement with the Barry White estate to say, hey, how can we all come to terms that will make everybody whole? How can we work this out? But everybody refused to kind of interact with her. That's what Miss Nicole is saying. Okay. So, damn, this was 2 hours. I thought it was damn near 1. All right. So that's where we are. That's where J Nolan falls into the docket. Furthermore, they go into Exhibit B, which is, this looks like an Instagram post by Miss Nicole Key. She says, who are the other rights holders? Epic Records owns the master, and I can keep you posted on the new writers and publishers. Does Future plan to perform the track? Okay, so this is Miss Nicole actually showing email correspondence with the licensing company who came to them about the sample, right? So she asked who are the other rights holders. They say Epic Records owns the master, and I can keep you posted on the new writers and publishers, which was supposed to be Kendrick. Kendrick was supposed to be, this is why she's angry. This is why both Rodney and Nicole are angry about Kendrick's involvement, because she didn't ask, is Kendrick going to be on it? She asked, who are the other rights holders? Who all is going to be entitled? Because as a rights holder, you get a percentage of the song. So who all is involved? Who all going to be there, right? So that we can work out what the share is supposed to be, right? They say Epic Records owns the master. I could keep you posted on the new writers and publishers. However, that keep you posted portion was never upheld. That's why they're so angry, right? She asked, does Future plan to perform the track at the Rolling Loud Festival? They say, to the best of our knowledge, it will not be performed. Future and Metro did turn around and perform that record, or at least they played it at the Rolling Loud Festival at Travis Scott's request, although the licensing guy said, to the best of our knowledge, it will not be performed. So they leaked the song out, not including Kendrick's part, at the Rolling Loud Festival when she was explicitly told, to the best of our knowledge, it will not be performed, right? So this is where she believes that bad faith was coming into the situation, and why they're so angry, and why that they're moving forward with the lawsuit, right? She says, how are they crediting Rodney? He replies, something along the lines of, and I'll need some additional information from you, contains a sample of Everlasting Bass written by Joe Cooley, wrote Rodney Oliver and Jeffrey Page, and performed by Rodney O and Joe Cooley, used courtesy of blank and published by blank. Excuse me. And of course, she was going to fill them in on the courtesy of published by blank. She asked also, does the label have the authority to negotiate the publishing? He says, I'm in contact with the proper parties in terms of negotiating the publishing side. She says, with all this, for me to assume I will need to reject their offer, I will submit a counter offer shortly. Okay? So she's basically saying that the offer that was brought to the table, since y'all are not able to provide me with all of the information I'm asking for, I will need to submit a counter offer shortly. Basically to say we're going to have to come back and reconvene and figure this out. But she posted this on Instagram. Proof of emails. She says, transparency matters. Despite legal threats and media spin, here's a real exchange showing just how many questions were still unanswered about the use of Everlasting Bass in Like That. No finalized credits, unclear rights holders, negotiations still in contact with the right parties, even the label's authority over publishing unconfirmed. We stood our ground. We asked the right questions. We didn't sign blindly. It's not about clout. It's about clarity, respect, and fair business. Okay? She then goes on to share this TMZ piece, and this is a piece from RBE's YouTube channel where he's actually reading about this online. And she gives RBE, if y'all don't know who RBE is, he Rare Breed Entertainment. That's a battle, or at least used to be a battle league. But now he kind of does what I do. Not to say doing what I do, but same thing. You know what I mean? Covering current events and topics in the music industry, stuff like that, and new music drops. We're doing kind of same shit. So she says, much respect to you, Rare Breed Entertainment, for breaking it down with clarity and integrity. You spoke on Rodney O's situation with honesty, balance, and respect, highlighting the importance of fairness in this industry without turning it into unnecessary drama. The way you reminded folks that business is business and people deserve to be paid for their work. Appreciate your voice in the culture. Keep shining. All right. They also cite another Instagram post from Miss Nicole. So they're basically just showing how she's been disclosing information about their legal issues on social media. We don't got to go through all of this word for word, bar for bar. Here's another one. Okay. Here's another one. So here she says, when I asked AI Chat GPT to generate professional images of me in the music industry, it repeatedly portrayed me as a black woman. Doesn't bother me, not in the way you might think. What does bother me is how often Mexican women are erased from the narrative, even by technology. It's as if our presence in music, leadership, and culture isn't even considered. But let me be clear. I am a Mexican woman, and I'm not only contributing to the culture, I'm protecting it. I deserve to be seen as I am, not as what others assume. Representation isn't a detail, it's power. Now, I don't know what the relevance is of that to this case, but we'll continue. Here she speaks on more about this everlasting bass. She goes to say that she's not an attorney. She just chose to fight. Okay, they tried to silence Rodney O, all this stuff. So these are the exhibits submitted by Miss Dorothy to say, hey, she keeps talking about this thing on social media. She needs to be a part of the confidentiality agreement as well, because she's out here talking too much. That's basically what's going on. And because they feel she's talking too much, they included my interview. Now, I don't know where this thing is going to go from here. I didn't expect to show up in nobody's legal filings when having that conversation, but you know, hey, she wanted to talk. She wanted to express her and Rodney's side of the story. We have had prior communications in the past about similar topics such as this, as she worked with 2 Live Crew and other people in the music industry in getting their music back from the labels. So I said, shit, why not? Right? I mentioned her in my initial video, and she ended up watching it, and we ended up having a conversation. Do I regret it? No. Do I have privileged information that that could be subpoenaed? Hell no. So I ain't really tripping. I'm just like, wow. Here I am. This shit is getting getting tricky out here, man. But at the end of the day, I do wish them the best. I wish everybody involved the best, right? From my personal purview, which has nothing to do with the legal ramifications or what is going on, I think if the Barry White estate does have the copyright and the sheet music to prove that they've been infringed upon in terms of interpolation and never cut in on it, if they can prove that, they should figure out when the proper time is to submit that so that they can get this thing wrapped up as quickly as possible. I don't think this thing needs a fucking trial. I'm gonna be honest. I'm not a legal professional. I don't think it needs a trial though. You're claiming you copyrighted it. Where's the copyright? Where's the sheet music? If they can prove that Rodney O indeed interpolated it, figure out what everybody's percentage is going to be. You can't consume somebody's music. You can't say I now own Everlasting Bass because you interpolated from a song we own. That's not how it works. We need to be cut in, right? We're now partners. That's what that happens. And not partners as in we're going to be doing business together and yucking it up, smiling in each other's face. But we're now partners in we now share profits from your side because you the one that did it. So whatever percentage that you've agreed to and that is on paper, we need to eat out of your plate. That's what needs to happen. Once they figure that out, everybody can move forward. Everybody can drop their fucking lawsuits and just put everybody properly in the paperwork if they can prove it. It's on Barry White and them to prove that they have the sheet music and the arrangement that can be shown for interpolation. Once that is proven, y'all could get rid of the shit against Kendrick, the shit against Metro, the shit against Future. Everybody could put their guns down, share in the fucking revenue, and then work out how do we move forward, because in the midst of all of this litigation, the people who are actually missing out on money are Rodney O, Joe Cooley, and the Barry White estate. Kendrick is on a motherfucking record-breaking tour. Metro Boomin is out here still eating off the royalties of both albums. Future and Metro both went out and did their own tour last year. They're going to continue to drop more music. They're going to continue to be profitable. Future is still going to probably drop another #1 album at some point this year, maybe 2, depending on what level of consistency he wants to work at. But Rodney O, Joe Cooley, and the Barry White estate, if they can prove that they should be cut in on this, they're missing out on licensing money, because in the interim of all of this, there's been multiple requests for like that to be featured in TV shows, film, etc., that have had to have been declined because they don't have the business buttoned up. So that's where I stand on this. And I think all of this could be figured out pretty simply. But that's just me not being a legal professional, right? Let me know what y'all think of all this down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider, and I will catch y'all on the next one. Everybody else's personal feelings have nothing to do with mine. Mine have nothing to do with them, okay? I'll catch y'all later. Peace.
King of my city and cul-de-sac. Coming out swinging like soldier rags. Leading my people like quarterback. Boy, I study this shit, I'm an almanac. Had to get up and grind. Knowledge is booming, I'm here to apply. Came with the chip and the dip, it just single the mind. We finna do more than survive. I need my check. Spinning the block for the Gouda. We hitting the jeweler to flood out the net. We don't do beef for computers, I'm straight out the sewer. We come when you rest. Niggas be looking perplexed, so keeping my foot on their neck. No map, I trust my gut for the quest. With drama, I'm fully abreast. I was ready for years and they doubted me. All of a sudden they tell me they proud of me. I've been dropping these haters like calories. First I'm out, I came back with some boundaries. Stand for my honor, but too raw, no corner. Packing the stick with a drummer. Wanna catch my bad, won't fumble. I done came too far to be humble.